Yes.
After Cohen's guilty plea, the president suddenly changed his tune towards Mr. Cohen, didn't he?
I would say I rely on what's in the report.
Well, he made the suggestion that Cohen family members had committed crimes. He targeted, for example, Cohen's father-in-law and repeatedly suggested that he was guilty of committing crimes, right?
Generally accurate.
Okay. On page 154, you give a powerful summary of these changing dynamics. And you said, I'm happy to have you read it, but I'm happy to do it if not.
I have it in front of me. Thank you.
Would you like to read it?
I would.
Can you read it out loud to everybody?
I would be happy to have you read it out.
Okay, very, very. We'll read it at the same time. The evidence concerning this sequence of events could support an inference that the president used inducements in the form of positive messages in an effort to get Cohen not to cooperate, and then turn to attacks and intimidation to deter the provision of information or to undermine Cohen's credibility once Cohen began cooperating.
I believe that's accurate.
Okay, and in my view, if anyone else in America engaged in these actions, they would have been charged with witness tampering. We must enforce the principle in Congress that you emphasize so well in the very last sentence of your report, which is that in America, no person is so high as to be above the law. I yield back, Mr. Chairman.
Thank you, Mr. Chairman. Just recently, Mr. Mueller, you said Mr. Liu was asking you questions. And Mr. Liu's question, I quote, the reason you didn't indict the president is because of the OLC opinion. And you answered, that is correct. But that is not what you said in the report, and it's not what you told Attorney General Barr. And in fact, in a joint statement that you released with DOJ on May 29th, after your press conference, your office issued a joint statement with the Department of Justice that said, the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that but for the OLC opinion, he would have found the president obstructed justice. The special counsel's report and his statement today made clear that the office concluded it would not reach a determination one way or the other whether the president committed a crime. There is no conflict between these statements. So, Mr. Miller, do you stand by your joint statement with DOJ that you issued on May 29th as you sit here today?
I would have to look at it more closely before I said I agree with it.
Well, my conclusion is that what you told Mr. Liu really contradicts what you said in the report, and specifically what you said apparently repeatedly to Attorney General Barr, and then you issued a joint statement on May 29th saying that the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying but for the OLC report that we would have found the president obstructed justice. So I just say there's a conflict. I do have some more questions. Mr. Mueller, there's been a lot of talk today about firing the special counsel and curtailing the investigation. Were you ever fired, Mr. Mueller, from the special?
What?
Were you ever fired as special counsel, Mr. Mueller?
No.
No. Were you allowed to complete your investigation unencumbered?
Yes.
And in fact, you resigned as special counsel when you closed up the office in late May 2019. Is that correct?
That's correct.
Thank you. Mr. Mueller, on April 18th, the Attorney General held a press conference in conjunction with the public release of your report. Did Attorney General Barr say anything inaccurate, either in his press conference or his March 24th letter to Congress summarizing the principal conclusions of your report?
Well, what you are not mentioning is a letter we sent on March 27th to Mr. Barr that raised some issues. And that letter speaks for itself.
But then I don't see how you that could be, since AG Barr's letter detailed the principal conclusions of your report, and you have said before that there wasn't anything inaccurate. In fact, you had this joint statement. But let me go on to another question. Mr. Mueller, rather than purely relying on the evidence provided by witnesses and documents, I think you relied a lot on media. I'd like to know how many times you cited the Washington Post in your report.
How many times I what?
Cited the Washington Post in your report.
I do not have knowledge of that figure, but well, that's it. I don't have knowledge of that figure.
I counted about 60 times. How many times did you cite the New York Times? I counted.
Again, I have no idea.
I counted about 75 times. How many times did you cite Fox News?
As with the other two, I have no idea.
About 25 times. I've got to say, it looks like Volume 2 is mostly regurgitated press stories. Honestly, there's almost nothing in Volume 2 that I couldn't already hear or know simply by having a $50 cable news subscription. However, your investigation cost the American taxpayers $25 million. Mr. Mueller, you cited media reports nearly 200 times in your report. Then in a footnote, a small footnote, number 7, page 15 of volume 2 of your report, you wrote, I quote, "This section summarizes and cites various news stories not for the truth of the information contained in the stories, but rather to place candidate Trump's response to those stories in context. Since nobody but lawyers reads footnotes, are you concerned that the American public took the embedded news stories?"
Time of the gentlelady has expired. The gentlelady from Washington.
Can Mr. Mueller answer the question?
No, we're running short on time. I said the gentlelady from Washington.
Thank you. Director Mueller, let's turn to the 5th of the obstruction episodes in your report, and that is the evidence of whether President Trump engaged in witness tampering with Trump campaign chairman Paul Manafort, whose foreign ties were critical to your investigation into Russia's interference in our elections. And this starts at volume 2, page 123. Your office got indictments against Manafort and Trump deputy campaign manager Rick Gates in 2 different jurisdictions, correct?
Correct.
And your office found that after a grand jury indicted them, Manafort told Gates not to plead guilty to any charges because, quote, he had talked to the president's personal counsel and they were going to take care of us. Is that correct?
That's accurate.
And according to your report, one day after Manafort's conviction on 8 felony charges, quote, the president said that flipping was not fair and almost ought to be outlawed. Is that correct?
I'm aware of that.
In this context, Director Mueller, what does it mean to flip?
Have somebody cooperate in a criminal investigation.
And how essential is that cooperation to any efforts to combat crime?
Well, I'm not going to go beyond that, characterizing that
Thank
effort.
you. In your report, you concluded that President Trump and his personal counsel, Rudy Giuliani, quote, made repeated statements suggesting that a pardon was a possibility for Manafort, while also making it clear that the president did not want Manafort to flip and cooperate with the government, end quote. Is that correct?
Correct.
And as you stated earlier, witness tampering can be shown where someone with an improper motive encourages another person not to cooperate with law enforcement. Is that correct?
Correct.
Now, on page 123 of volume 2, you also discuss the president's motive, and you say that as court proceedings move forward against Manafort, President Trump, quote, discussed with aides whether and in what way Manafort might be cooperating and whether Manafort knew any information that would be harmful to the president, end quote. Is that correct?
And that was a quote from?
From page 123, volume 2.
I have it. Thank you. Yes.
And when someone tries to stop another person from working with law enforcement and they do it because they're worried about what that person will say, it seems clear from what you wrote that this is a classic definition of witness tampering. Now, Mr. Manafort did eventually decide to cooperate with your office, and he entered into a plea agreement, but then he broke that agreement. Can you describe what he did that caused you to tell the court that the agreement was off?
I refer you to the court proceedings on that issue.
So on page 127 of volume 2, you told the court that Mr. Manafort lied about a number of matters that were material to the investigation, and you said that the Manafort's lawyers also, quote, regularly briefed the president's lawyers on topics discussed and the information that Manafort had provided in interviews with the special counsel's office. Does that sound right?
And the source of that is?
That's page 127, volume 2. That's a direct
If
quote.
it's from the report, yes, I'd
Thank
support
you.
it.
And 2 days after you told the court that Manafort broke his plea agreement by lying repeatedly, did President Trump tell the press that Mr. Manafort was, quote, very brave because he did not flip? This is page 128 of volume 2.
If it's in the report, I support it as it is set forth.
Thank you. Director Mueller, in your report, you make a very serious conclusion about the evidence regarding the president's involvement with the Manafort criminal proceedings. Let me read to you from your report. Evidence concerning the president's conduct toward Manafort indicates that the president intended to encourage Manafort to not cooperate with the government. It is clear that the president both publicly and privately discouraged Mr. Manafort's cooperation or flipping while also dangling the promise of a pardon if he stayed loyal and did not share what he knew about the president. Anyone else who did these things would be prosecuted for them. We must ensure that no one is above the law. And I thank you for being here, Director Mueller. Yield back.
Gentleman from Pennsylvania.
Thank you, Mr. Chairman. Mr. Mueller, I'm over here, I'm sorry. Mr. Mueller, are you familiar with the now expired independent counsel statute? It's the statute under which Ken Starr was appointed.
Ken Starr did what? I'm sorry.
Are you familiar with the independent counsel statute?
Are you talking about the one that we operating under now or a previous?
No, under which Ken Starr was appointed?
I am not that familiar with that, but I'd be happy to take your question.
Well, the Clinton administration allowed the independent counsel statute to expire after Ken Starr's investigation. The final report requirement was a major reason why the statute was allowed to expire. Even President Clinton's AG, Janet Reno, expressed concerns about the final report requirement. And I'll quote AG Reno. She said, on one hand, the American people have an interest in knowing the outcome of an investigation of their highest officials. On the other hand, the report requirement cuts against many of the most basic traditions and practices of American law enforcement. Under our system, we presume innocence and we value privacy. We believe that information obtained during a criminal investigation should, in most cases, be made public only if there is an indictment and prosecution, not in a lengthy and detailed report filed after a decision has been made not to prosecute. The final report provides a forum for unfairly airing a target's dirty laundry, and it also creates yet another incentive for an independent counsel to over-investigate in order to justify his or her tenure and to avoid criticism that the independent counsel may have left a stone unturned. Again, Mr. Mueller, those are AG Reno's words. Didn't you do exactly what AG Reno feared? Didn't you publish a lengthy report unfairly airing the target's dirty laundry without recommending charges?
I disagree with that.
Okay. Did any of your witnesses
Can I
have the chance to be cross-examined?
Can I just finish my answer on that?
Quickly.
I operate under the current statute, not the original
Okay.
statute. So I am most familiar with the current statute, not the older statute.
Did any of the witnesses have a chance to be cross-examined?
Did any of the witnesses in our investigation?
Yes.
I'm not going to answer that.
Okay. Did you allow the people mentioned in your report to challenge how they were characterized?
I'm not going to get into
Okay.
that.
Given that AG Barr stated multiple times during his confirmation hearing that he would make as much of your report public as possible, did you write your report knowing that it would likely be shared with the public?
No.
Did knowing that the report could and likely would be made public, did that alter the contents which you included?
I can't speak to that.
Despite the expectations that your report would be released to the public, you left out significant exculpatory evidence. In other words, evidence favorable to the president, correct?
Well, I actually would disagree with you. I think we strove to put into the report exculpatory evidence as well.
Talk got into that with you, where you said there was evidence you left out.
Well, you make a choice as to what goes into
Isn't it true,
indictment.
Mr. Mueller, isn't it true that on page 1 of volume 2, you state, when you're quoting the statute, you had an obligation to either prosecute or not prosecute?
Well, generally that is the case.
Right.
Although most cases are not done in the context of the president.
And in this case, you made a decision not to prosecute, correct?
No, we made a decision not to decide whether to prosecute or not.
So essentially what your report did was everything that AG Reno warned against.
I can't agree with that
Okay,
characterization.
well, what you did is you compiled nearly 450 pages of the very worst information you gathered against the target of your investigation, who happens to be the President of the United States. And you did this knowing that you were not going to recommend charges and that the report would be made public.
Not true.
Mr. Mueller, as a former officer in the United States JAG Corps, I prosecuted nearly 100 terrorists in a Baghdad courtroom. I cross-examined the Butcher of Fallujah in defense of our Navy SEALs. As a civilian, I was elected a magisterial district judge in Pennsylvania, so I'm very well versed in the American legal system. The drafting and the publication of some of the information in this report without an indictment, without prosecution, frankly flies in the face of American justice. And I find those facts, this entire process, un-American. I yield the remainder of my time to my colleague, Jim Jordan.
Director Mueller, the third FISA renewal happens a month after you're named special counsel. What role did your office play in the third FISA renewal of Carter Page?
Not going to talk to that.
Time of the gentleman has expired. The gentlelady from Florida.
Director Mueller, a couple of my colleagues right here wanted to talk to you or ask you about lies. So let's talk about lies. According to your report, page 9, volume 1, witnesses lied to your office and to Congress. Those lies materially impaired the investigation of Russia interference, according to your report. Other than the individuals who pled guilty to crimes based on their lying to you and your team, did other witnesses lie to you?
I think there are probably a spectrum of witnesses in terms of those who are not telling the full truth, and those are outright liars.
Thank you very much. Outright liars. It is fair to say then that there were limits on what evidence was available to your investigation of both Russia election interference and obstruction of justice.
That's true, and it's usually the case.
And that lies by Trump campaign officials and administration officials impeded your investigation.
I would generally agree with that.
Thank you so much, Director Mueller. You will be hearing more from me in the next hearing, so I yield the balance of my time to Mr. Correa. Thank you.
Mr. Mueller, first of all, let me welcome you. Thank you for your service to our country. You're a hero, Vietnam War vet, wounded war vet. We won't forget your service to our country.
Thank you, sir.
I may begin. Because of time limits, we have gone in depth on only 5 possible episodes of obstruction. There's so much more. And I want to focus on another section of obstruction, which is the president's conduct concerning Michael Flynn, the president's national security advisor. In early 2017, the White House counsel and the president were informed that Mr. Flynn had lied to government authorities about his communications with the Russian ambassador during the Trump campaign and transition. Is this correct?
Correct.
If a hostile nation knows that a U.S. official has lied publicly, that can be used to blackmail that government official, correct?
I'm not going to speak to that. I don't disagree with it necessarily, but I'm not going to speak to any more to that issue.
Thank you very much, sir. Flynn resigned on February 13, 2016. And the very next day, when the president was having lunch with New Jersey Governor Chris Christie, did the president say, open quotes, "Now that we fired Flynn, the Russia thing is over," close quote. Is that correct?
Correct.
And is it true that Christie responded by saying, open quotes, "No way, and this Russia thing is far from over," close quote?
That's the way we have it in the report.
Thank you. And after the president met with Christie, later that same day, the president arranged to meet with then FBI Director James Comey, alone in the Oval Office, correct?
Correct, particularly if you have the citation to the report.
Page 3940, volume 2.
Thank you very much.
And according to Comey, the president told him, "I hope," open quote, "I hope you can see your way to letting this thing go, to letting Flynn go. He's a good guy, and I hope you can let it go," close quote. Page 40, volume 2.
Accurate.
What did Comey understand the president to be asking?
I'm not going to get into what was in Mr. Comey's mind.
Comey understood this to be a direction because of the president's position and the circumstances of the one-to-one meeting, page 40, volume 2?
Well, I understand it's in the report, and I support it as being in the report.
Thank you, sir. Even though the president publicly denied telling Comey to drop the investigation, you found, open quote, substantial evidence corroborating Comey's account over the president's. Is this correct?
That's correct.
The president fired Comey on May 9th. Is that correct, sir?
I believe that's the accurate date.
That's page 77, volume 2. You found substantial evidence that the catalyst for the president's firing of Comey was Comey's, open quote, unwillingness to publicly state that the president was not personally under investigation.
I'm not going to delve more into the details of what happened. If it's in the report, then I'm supportive because it's already been reviewed and appropriately appears in the report.
And that's page 75, volume 2.
Thank you.
Thank you. And in fact, the very next day, the president told the Russian foreign minister, open quote, I just fired the head of the FBI. He was crazy, a real nut job. I faced great pressure because of Russia. That's taken off. I'm not under investigation, close quote. Is that correct?
That's what was written in the report, yes.
Time of the gentleman has expired.
Thank you, sir.
Gentleman from Virginia.
Thank you, Mr. Chairman. Mr. Mueller, we've heard a lot about what you're not going to talk about today. So let's talk about something that you should be able to talk about, the law itself, the underlying obstruction statute, and your creative legal analysis of the statutes in Volume 2, particularly your interpretation of 18 U.S.C. 1512C. Section 1512C is an obstruction of justice statute created as part of auditing and financial regulations for public companies. And as you write on page 164 of Volume 2, this provision was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. And to read the statute, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under the statute or imprisoned not more than 20 years or both. Your analysis and application of the statute proposes to give Clause C2 a much broader interpretation than commonly used. First, your analysis proposes to read Clause C2 in isolation, reading it as a freestanding, all-encompassing provision prohibiting any act influencing a proceeding if done with an improper motive. And second, your analysis of the statute to apply this proposes to apply this sweeping prohibition to lawful acts taken by public officials exercising their discretionary powers if those acts influence a proceeding. So, Mr. Mueller, I'd ask you, in analyzing the obstruction, you state that you recognize that the Department of Justice and the courts have not definitively resolved these issues, correct?
Correct.
You'd agree that not everyone in the Justice Department agreed with your legal theory of the obstruction of justice statutes, correct?
I'm not going to be involved in the discussion on that at this juncture.
In fact, the Attorney General himself disagrees with your interpretation of the law, correct?
I leave that to the Attorney General to identify.
And you would agree that prosecutors sometimes incorrectly apply the law, correct?
I would have to agree with that one. Yes.
And members of your legal team, in fact, have had convictions overturned because they were based on an incorrect legal theory, correct?
I don't know to what you advert. We've all who spent time in the trenches trying cases have not won every one of those cases.
Well, let me ask you about one in particular. One of your top prosecutors, Andrew Weissman, obtained a conviction against auditing firm Arthur Andersen, lower court, which was subsequently overturned in a unanimous Supreme Court decision that rejected the legal theory advanced by Weissman, correct?
Well, I'm not going to get into delve into
Let me read from that. Maybe it'll
May I just finish? May I just finish my answer to say that I'm not going to get involved in a discussion on that. I will refer you to that citation that you gave me at the outset for the lengthy discussion on just what you're talking about, and to the extent that I have anything to say about it, it is what we've already put into the report on that issue.
I am reading from your report when discussing this section, and I'll read from the decision of the Supreme Court unanimously reversing Mr. Weissman when he said, indeed, it's striking how little culpability the instructions required. For example, the jury was told that even if petitioner honestly and sincerely believed his conduct was lawful, the jury could convict. The instructions also diluted the meaning of corruptly such that it covered innocent conduct.
Let me just say, put in a word for...
Let me move on. I have limited time. Your report takes the broadest possible reading of this provision and applying it to the president's official acts, and I'm concerned about the implications of your theory for over-criminalizing conduct by public officials and private citizens alike. So to emphasize how broad your theory of liability is, I want to ask you about a few examples. On October 11th, 2015, during the FBI investigation into Hillary Clinton's use of a private email server, President Obama said, "I don't think it posed a national security problem." And he later said, "I can tell you that this is not a situation in which America's national security was endangered." Assuming for a moment that his comments did influence the investigation, couldn't President Obama be charged under your interpretation with obstruction of justice?
Well, again, I refer you to the report, but let me say with Andrew Weissman, who is one of the more talented attorneys that we have and have on board.
Okay, well, I'll take that
over a period of time. He has run a number of units.
I have very limited time. In August 2015, a very senior DOJ official called FBI Deputy Director Andrew McCabe, expressing concern that FBI agents were still openly pursuing the Clinton Foundation probe. The DOJ official was apparently very pissed off, quote unquote. McCabe questioned this official, asking, "Are you telling me I need to shut down a validly predicated investigation?" To which the official replied, "Of course not." This seems to be a clear example of somebody within the executive branch attempting to influence an FBI investigation. So under your theory, couldn't that person be charged with obstruction as long as a prosecutor could come up with a potentially corrupt motive?
I refer you to our lengthy dissertation on exactly those issues that appears in at the end of the report.
Mr. Mueller, I'd argue that it says above the Supreme Court, equal justice under law.
Time of the gentleman has expired.
Not stretched.
Our intent was to conclude this hearing in 3 hours. Given the break, that would bring us to approximately 11:40. With Director Mueller's indulgence, we will be asking our remaining Democratic members to voluntarily limit their time below the 5 minutes so that we can complete our work as close to that time frame as possible. And I recognize the gentlelady from Pennsylvania.
Thank you, Director Mueller. I want to ask you some questions about the president's statements regarding advanced knowledge of the WikiLeaks dumps. So the president refused to sit down with your investigators for an in-person interview, correct?
Correct.
So the only answers we have to questions from the president are contained in Appendix C to your report.
That's correct.
Okay, so looking at Appendix C on page 5, you asked the president over a dozen questions about whether he had knowledge that WikiLeaks possessed or might possess the emails that were stolen by the Russians.
I apologize.
Sure.
Can you start it again?
Okay, sure. So we're looking at Appendix C.
Right.
And at Appendix C, page 5, you asked the president about a dozen questions about whether he had knowledge that WikiLeaks possessed the stolen emails that might be released in a way helpful to his campaign or harmful to the Clinton campaign. Is that correct? You asked those questions? Okay. In February of this year, Mr. Trump's personal attorney, Michael Cohen, testified to Congress under oath that, quote, Mr. Trump knew from Roger Stone in advance about the WikiLeaks drop of emails, end quote. That's a matter of public record, isn't it?
Well, are you referring to the report or some other public record?
This was testimony before Congress by Mr. Cohen. Do you know if he told you?
I'm not familiar with it, explicitly familiar with what he testified to before Congress.
Okay. Let's look at an event described on page 18 of volume 2 of your report. Now, and we're going to put it up in a slide, I think. According to Deputy Campaign Manager Rick Gates, in the summer of 2016, he and candidate Trump were on the way to an airport shortly after WikiLeaks released its first set of stolen emails. And Gates told your investigators that candidate Trump was on a phone call, and when the call ended, Trump told Gates that more releases of damaging information would be coming, end quote. Do you recall that from the report?
If it's in the report, I support it.
Okay, and that's on page 18 of volume 2. Now, on page 77 of volume 2, your report also stated, quote, in addition, some witnesses said that Trump privately sought information about future WikiLeaks releases, end quote. Is that correct?
Correct.
Now, in Appendix C, where the president did answer some written questions, he said, quote, I do not recall discussing WikiLeaks with him, nor do I recall being aware of Mr. Stone having discussed WikiLeaks with individuals associated with my campaign, end quote. Is that correct?
If it's from the report, it is correct.
Okay. So is it fair to say the president denied ever discussing WikiLeaks with Mr. Stone and denied being aware that anyone associated with his campaign discussed WikiLeaks with Stone?
I'm sorry, could you repeat that one?
Is it fair then that the president denied knowledge of himself or anyone else discussing WikiLeaks dumps with Mr. Stone?
Yes.
Okay. And with that, I would yield back.
Thank you, ma'am.
Thank you, Mr. Chair. Mr. Mueller, over here. Mr. Mueller, did you indeed interview for the FBI director job one day before you were appointed as special counsel?
My understanding, I was not applying for the job. I was asked to give my input on what it would take to do the job, which triggered the interview you're talking about.
So you don't recall on May 16, 2017, that you interviewed with the president regarding the FBI director job?
I interviewed with the president, and
Regarding the FBI director job?
It was about the job and not about me applying for the job.
So your statement here today is that you didn't interview to apply for the FBI director job?
That's correct.
So did you tell the vice president that the FBI director position would be the one job that you would come back for?
Don't recall that one.
You don't recall that?
No.
Okay. Given your 22 months of investigation, tens of millions of dollars spent, and millions of documents reviewed, did you obtain any evidence at all that any American voter changed their vote as a result of Russians' election interference?
I'm not going to speak to that.
You can't speak to that? After 22 months of investigation, there's not any evidence in that document before us that any voter changed their vote because of their interference, and I'm asking you based on all the documents that you reviewed.
That was outside our purview.
Russian meddling was outside your purview?
But the impact of that meddling was undertaken by other agencies.
Okay, you stated in your opening statement that you would not get into the details of the Steele dossier. However, multiple times in Volume 2 on page 23, 27, and 28, you mentioned the unverified allegations. How long did it take you to reach the conclusion that it was unverified?
I'm not going to speak to that.
It's actually in your report multiple times that it's unverified, and you're telling me that you're not willing to tell us how you came to the conclusion that it was unverified.
True.
When did you become aware that the unverified Steele dossier was included in the FISA application to spy on Carter Page?
I'm sorry, what was the question?
When did you become aware that the unverified Steele dossier was included in the FISA application to spy on Carter Page?
I'm not going to speak to that.
Your team interviewed Christopher Steele, is that correct?
Not going to get into that.
You can't tell this committee as to whether or not you interviewed Christopher Steele in a 22-month investigation with 18 lawyers.
As I said at the outset, that is one of the investigations that is being handled by others in the Department of Justice.
Yeah, but you're here testifying about this investigation today. And I am asking you directly, did any members of your team or did you interview Christopher Steele in the course of your investigation?
And I am not going to answer that question, sir.
You had 2 years to investigate. Not once did you consider it worthy to investigate how an unverified document that was paid for by a political opponent was used to obtain a warrant to spy on the opposition political campaign. Did you do any investigation in that whatsoever?
I do not accept your characterization of what occurred.
What would be your characterization?
I'm not going to speak any more to it.
So you can't speak any more to it, but you're not going to agree with my characterization. Is that correct?
Yes.
The FISA application makes reference to Source One, who was Christopher Steele, the author of the Steele dossier. The FISA application says nothing Sources One's reason for conducting the research into candidate one's ties to Russia, based on Sources One previous reporting history with FBI, whereby Source One provided reliable information to the FBI. The FBI believes Source One's reporting herein to be credible. Do you believe the FBI's representation that Source One's reporting was credible to be accurate?
I'm not going to answer that.
So you're not going to respond to any of the questions regarding Christopher Steele or your interviews with them?
Well, as I said at the outset this morning, that was one of the investigations that I could not speak to.
Well, I don't understand how, if you interviewed an individual on the purview of this investigation that you're testifying to us today, that you've closed that investigation, how that's not within your purview to tell us about that investigation and who you interviewed.
I have nothing to add.
Okay, well, I can guarantee that the American people want to know. And I'm very hopeful and glad that AG Barr is looking into this and the Inspector General is looking into this, because you're unwilling to answer the questions of the American people as it relates to the very basis of this investigation into the president and the very basis of this individual who you did interview. You're just refusing to answer those questions. Can't the president fire the FBI director at any time without reason under Article 1 of the Constitution?
Yes.
Article 2?
Yes.
That's correct. Can't he also fire you as special counsel at any time without any reason?
I believe that to be the case.
Under Article 2?
Hold on just a second. You said without any reason. I know that special counsel can be fired, but I'm not certain it extends to for whatever reason is given.
Well, and you've testified that you weren't fired. You were able to complete your investigation in full. Is that correct?
I'm not going to add to what I've stated before.
My time's expired.
Gentleman's time has expired. The gentlelady from Pennsylvania. From Texas.
Thank you, Mr. Chairman, and thank you, Mr. Mueller, for being with us close to the afternoon now. Director Mueller, now I would like to ask you about the president's answers relating to Roger Stone. Roger Stone was indicted for multiple federal crimes, and the indictment alleges that Mr. Stone discussed future WikiLeaks email releases with the Trump campaign. Understanding there's a gag order on the Stone case, I will keep my questions restricted to publicly available information. Mr. Stone's indictment...
Let me just say at the outset, I don't mean to disrupt you, but I'm not... I would like some demarcation of that which is applicable to this, but also in such a way that it does not hinder the other prosecution that is taking place in D.C.
I understand that. I'm only going to be talking about the questions that you asked in writing to the president.
Thank you, ma'am.
That relate to Mr. Stone. Mr. Stone's indictment states, among other things, the following, quote, Stone was contacted by senior Trump officials to inquire about future releases of Organization One being WikiLeaks. The indictment continues, quote, Stone thereafter told the Trump campaign about potential future releases of damaging material by WikiLeaks. So in short, the indictment alleges that Stone was asked by the Trump campaign to get information about more WikiLeaks releases, and that Stone, in fact, did tell the Trump campaign about potential future releases, correct?
Yes, ma'am, but I see you're quoting from the indictment, and even though the indictment is a public document, I feel uncomfortable discussing anything having to do with the Stone prosecution.
Right, the indictment is of record, and we pulled it off of the, I'm reading straight from it. Well, turning back to the president's answers to your questions, Dan, on this very subject, the president denied ever discussing future WikiLeaks releases with Stone and denied knowing whether anyone else on his campaign had those discussions with Stone. If you had learned that other witnesses, putting aside the president, if other witnesses had lied to you investigators in response to Pacific's questions, whether in writing or in an interview, could they be charged with false statement crimes?
Well, I'm not going to speculate. I think you're asking for me to speculate, given a set of circumstances.
Well, let's put it more specific. What if I had made a false statement to an investigator on your team? Could I go to jail for up to 5 years?
Yes.
Yes.
Although it's Congress, so.
Well, that's the point, though, isn't it? That no one is above the law.
That's true.
Not you, not the Congress, and certainly not the president. And I think it's just troubling to have to hear some of these things. And that's why the American people deserve to learn the full facts of the misconduct described in your report, for which any other person would have been charged with crimes. So thank you for being here. And again, the point has been underscored many times, but I'll repeat it. No one is above the law. Thank you.
Thank you, ma'am.
The gentleman from North Dakota is recognized.
Mr. Mueller, how many people did you fire? How many people on your staff did you fire during the course of the investigation?
How many people
did you fire?
I'm not going to discuss that.
You fired, according to the Inspector General's report, attorney number 2 was let go, and we know Peter Strzok was let go, correct?
Yes, and there may have been other persons on other issues that have been either transferred or fired
Peter Strzok testified before this committee on July 12, 2018, that he was fired because you were concerned about preserving the appearance of independence. Do you agree with this testimony?
Say that again, if you could.
He said he was fired at least partially because you were worried about concerned about preserving the appearance of independence with the special counsel's investigation. Do you agree with that statement?
The statement was by whom?
Peter Strzok at this hearing.
And I am not familiar with that.
Did you fire him because you were worried about the appearance of independence of the investigation?
No, he was transferred as a result of instances involving texts.
Do you agree that your office did not only have an obligation to operate with independence, but to operate with the appearance of independence as well?
Absolutely. We strove to do that over the 2 years.
Andrew Weissman.
Part of that was making certain that.
Andrew Weissman's one of your top attorneys?
Yes.
Did Weissman have a role in selecting other members of your team?
He had some role, but not a major role.
Andrew Weissman attended Hillary Clinton's election night party. Did you know that before or after he came onto the team?
Don't know when I found that out.
On January 30th, 2017, Weissman wrote an email to Deputy Attorney General Yates stating, "I am so proud and in awe," regarding her disobeying a direct order from the president. Did Weissman disclose that email to you before he joined the team?
Yeah, I'm not going to talk about that.
Is that not a conflict of interest?
I'm not going to talk about that.
Are you aware that Ms. Jeannie Rhee represented Hillary Clinton in litigation regarding personal emails originating from Clinton's time as Secretary of State?
Yes.
Did you know that before she came on the team?
No.
Aaron Zelbley, the guy sitting next to you, represented Justin Cooper, a Clinton aide who destroyed one of Clinton's mobile devices. And you must be aware by now that 6 of your lawyers donated $12,000 directly to Hillary Clinton. I'm not even talking about the $49,000 they donated to other Democrats, just the donations to the opponent who was the target of your investigation.
Can I speak for a second to the hiring practices?
Sure.
We strove to hire those individuals that could do the job. I've been in this business for almost 25 years. And in those 25 years, I have not had occasion once to ask somebody about their political affiliation. It is not done. What I care about is the capability of the individual to do the job and do the job quickly and seriously and with integrity.
But that's what I'm saying, Mr. Mueller. This isn't just about you being able to vouch for your team. This is about knowing that the day you accepted this role, you had to be aware no matter what this report concluded, half of the country was going to be skeptical of your team's findings. And that's why we have recusal laws that define bias and perceive bias for this very reason. 28 United States Code 528 specifically lists not just political conflict of interest, but the appearance of political conflict of interest. It's just simply not enough that you vouch for your team. The interested justice demand that no perceived bias exists. I can't imagine a single prosecutor or judge that I have ever appeared in front of would be comfortable with these circumstances where over half of the prosecutorial team had a direct relationship to the opponent of the person being investigated.
Well, let me one other fact that I put on the table, and that is we hired 19 lawyers over the period of time. Of those 19 lawyers, 14 of them were transferred from elsewhere in the Department of Justice. Only 5 came from outside.
And so half of them had a direct relationship, political or personal, with the opponent of the person you were investigating. And that's my point. I wonder if not a single word in this entire report was changed, but rather the only difference was we switched Hillary Clinton and President Trump. If Peter Strzok had texted those terrible things about Hillary Clinton instead of President Trump, if a team of lawyers worked for, donated thousands of dollars to, and went to Trump's parties instead of Clinton's, I don't think we'd be here trying to prop up an obstruction allegation. My colleagues would have spent the last 4 months accusing your team of being bought and paid for by the Trump campaign, and we couldn't trust a single word of this report. They would still be accusing the president of conspiracy with Russia, and they would be accusing your team of aiding and abetting in that, with that conspiracy. And with that, I yield back.
Gentleman yields back. The gentleman from Colorado.
Director Mueller, thank you for your service to our country. I'd like to talk to you about one of the other incidents of obstruction, and that's the evidence in your report showing the president directing his son and his communications director to issue a false public statement in June of 2017 about a meeting between his campaign and Russian individuals at Trump Tower in June of 2016. According to your report, Mr. Trump Jr. was the only Trump associate who participated in that meeting and who declined to be voluntarily interviewed by your office. Is that correct?
Yes.
Did Mr. Trump Jr. or his counsel ever communicate to your office any intent to invoke his Fifth Amendment right against self-incrimination?
I'm not going to answer that.
You did pose written questions to the president about his knowledge of the Trump Tower meeting. You also asked him about whether or not